Next up, we're going to talk about contracting considerations. I have to give a little disclaimer. It basically says I'm a lawyer, I'm not your lawyer, so I can't give any specific legal advice, but I'm here to give some just general educational information. So let's talk a little bit about purchase contracts for hemp. One of the most important things to think about is having a contract. I know that in the economics section, some of our economists are going to discuss why this is so important. But having a purchase contract is really a good way to protect your investment if you're going to invest the money in getting started in the hemp growing process. You want to make sure that that contract is in writing. I know that that may sound a little bit funny if you're not involved in agriculture. Why would you have a contract not in writing? But the truth is, historically in agriculture, we've done a lot of business on a handshake verbal contract. So I would really encourage you to have any type of purchase contract for hemp put in writing. And then you need to read the written contract. And this is a place where, again, those of us in agriculture probably aren't always the best at this. A lot of times, I think maybe there is a written contract, or we get a form contract somewhere and just fill it out, and we don't really read some of that legalese, which I know isn't super fun to get through. But reading the contract and understanding the contents is always really important. I think it's even more so true when you're dealing with hemp. And part of that is because it's such a new industry, and there's really not kind of a standard contract that's been used forever that everyone understands, and we've had lawyers and judges make rulings on, so we kind of know how they'll play out. So I'd really encourage you to make sure you read your contracts. I'd also really encourage you to have an attorney review the contract. And it needs to be an attorney who's representing you, not a lawyer who's working for the other party. And so sometimes you'll hear purchasers say things like, well, we've had a lawyer look over it and this contract is good to go. That's fine, but that lawyer was looking over it with the purchaser's interest in mind, right? Representing the purchaser, not the grower. And a lot of the contracts that I've seen kind of in preparing for this presentation and just kind of educating myself on the hemp industry have been really unfriendly and almost unfair to growers in a lot of instances. So I'd really, again, make sure you've got a good contract that you've had reviewed by an attorney who can kind of help protect your interests. The last thing I would say is it's a good idea to do some research on the buyer. Again, just because hemp is kind of a new industry, right, in relation to a lot of the other ag industries, doing some research just to see what's out there. Checking with the Better Business Bureau, right? Seeing if there's any comments about these buyers on, Facebook groups for hemp growers, or Google them and see what kind of articles come up. Doing that type of due diligence before you enter into a contract is really important as well. So in looking at agriculture contracts generally, we see two main types of contractual agreements. The first is a cash contract, and the second would be kind of a share type agreement. And so for a cash contract, those are by far the most common, I think, in the majority of the ag industry. And that's simply a contract for purchase for a set price. So maybe that's going to be a certain price per acre or a certain price per pound. In hemp, we'll see in a minute, there's some different measurements, but a set cash price that is going to be paid for the product. Sometimes you'll also see share contracts, and that's where essentially, right, the grower and the purchaser are going to share in the costs of production, and then they're going to share in the proceeds that come from that production. So those are kind of, in general ag, the two types of contracts that we see. In looking at hemp contracts, and I certainly don't claim that I've looked at every type of contract, but some of the more common ones I've seen, cash prices have been more common. I've seen dollars per percent CBD. So you get paid so many dollars for whatever percent CBD the crop measures. I've seen dollars per pound. I've seen dollars per acre. There have been one contract I've seen that said market value at the end of the growing season. And so I would caution you on that one, right? And if you listen to the videos with the economists, market price for hemp has really fluctuated, and there's been a huge change of that over the last year. And so keep in mind that if you agree to a contract that's market value at the end of the growing season, that's not a set rate, right? That's subject to really change. And so you want to make sure to pay attention to any language like that. Another important consideration is when and how is payment going to be made. So, in these contracts, a lot of times there'll be provisions that talk about when payment is due, right? Maybe it's within 30 days of delivery. Look for any sort of protections if payment is late, right? Are there late penalties? Is there any sort of bond that's going to be required in case a payment isn't made? Also pay attention to how payment is going to be made. Some contracts you see a cash or check payment allowed. Some contracts it's payment in kind. And so the grower gets some amount of physical product, right, that they grew. This amount is yours, and that's the payment. So again, just pay attention to how those contracts are structured. Additionally, how you set up the payment structure of the contract can affect your ability to qualify for crop insurance and any sort of government programs that you might qualify for. And so part of the reason there is a grower has to have what's called an insurable interest or an ownership interest in the crop before they can qualify for crop insurance. So sometimes you'll see, for example, if you have a cash lease with a landlord and a tenant. On a cash lease, the landlord wouldn't qualify for crop insurance because he wouldn't have any sort of insurable interest, right, or risk of production in that crop. Flip that, and if you had a share lease, right, where maybe the landowner and the tenant were going to share and the tenant gets 2/3 and the landowner gets 1/3 of the proceeds, now the landowner would have an insurable interest because he's got risk of production in that crop. So that's something to keep in mind when you're looking at how these leases are structured. Additionally, at the Farm Service Agency, if there's any sort of program that comes up that hemp might qualify for, you generally have to have some risk of loss in order to qualify for that program. So again, that's going to, depending on how you structure that lease as far as ownership, interest, control, and risk, may impact whether or not you can qualify for these insurance products or potential government program assistance. One last thing I want to note when we're talking about contracts is Texas specific. In 2017, the Texas legislature passed the Texas Producer Protection Act. Essentially what this act does is it says that any contract for the purchase of an agricultural commodity has to expressly and conspicuously state whether it's an acreage contract or a quantity contract. So let me explain the difference. An acreage contract requires that a producer deliver production of a product grown on certain land. So let's say I have 100 acres. An acreage contract is where I would agree to sell the buyer whatever I grow on that 100 acres, right? It's not based on how much I produce. Whatever amount comes off the 100 acres is what I am contracting. That's an acreage contract. A quantity contract is where the producer is going to deliver a set quantity to the buyer regardless of the total amount grown. So in that example, if I have 100 acres, how much I grow on that acreage doesn't matter. If I agree to contract a certain number of pounds to the buyer, it's that contractual quantity that matters. So again, in Texas, for an ag commodity purchase contract, you're going to have it expressly stated in the contract whether it's an acreage contract or a quantity contract. Additionally, there's a little bit of extra protection in the statute that says if it's an acreage contract, the purchaser may not sue the grower unless the grower knowingly fails to deliver all the product grown on the land. Okay, and so essentially this is protection for a grower that says, look, if you enter into an acreage contract, right, where you're going to sell somebody all of the product grown on that acreage, the producer cannot sue you for failure to comply with that contract in delivering the acreage requirement unless you knowingly fail to make that delivery. And in the law, knowing is defined as being aware of the nature of your conduct or the circumstances exist, or you're aware that this conduct is reasonably certain to cause the result. Okay, so you have to, it's not necessarily intentional, right? But you have to be aware or reasonably certain that you're not delivering everything on that acreage before you could be liable to the purchaser. So again, that's going to be a place where there's some extra protection for a grower. And so another thing that may do is cause a purchaser to sort of shy away from an acreage contract. But just be aware that statute does exist.